was proud of the fact that when my mandate ended, the court was busier than it had ever been in its history. We had about 6 proceedings going before trial chambers. And I felt that was a great success. Some of the other successes may not be so obvious. The way in which the court handled the pandemic, I think, was most remarkable. Within a couple of weeks, staff had been removed from the building and were working from home, were equipped to work from home. Investigations continued, although with certain protections in place because of the danger of infection. And there was at least one surrender that occurred during that time to bring another person before the court. There was an appeal that was run with social distancing and people being off-site, counsel being off-site as well as on-site in the courtroom, and it was very successfully done, which was encouraging because then it showed that proceedings could go ahead notwithstanding the pandemic. I think that was a significant success. You may also remember that we came under a very severe attack by a hostile U.S. administration. The person I served as prosecutor was sanctioned under an executive order, as was one of my senior colleagues. And yet the court navigated that very successfully with the support of the Assembly of States Parties and certain key states parties. So those were things that I think were great successes in terms of the court's operations. But for low points, of course, is when cases fail. I think what is positive about that is we were always willing to learn from those failures. We didn't brush them under the carpet. We faced up to why the difficulties had resulted in the outcomes that they did. But in other, what gave me satisfaction? Things that aren't obvious to anybody, I suppose, except to the people actually working at the court. We created the concept and implemented the concept of integrated investigative teams, combining lawyers, investigators, and others with different forensic skills into an integrated unit that would conduct investigations. And we broke down the silos that existed within the office, integrated people's activities, and I think really improved the efficiency and effectiveness of the work of the Office of the Prosecutor. I can't say that there was anything that I didn't expect, simply because I expected that I was going to have to learn everything. I mean, I had the background, obviously, of the UN tribunals, which was very helpful. But of course, I was entering into a very different kind of institution. I was very comfortable with the legal end of things, with the lawyering part of it. I had worked with investigators all my professional life, but now I had responsibility for them. And of course, I had a lot to learn there in terms of how to support their work. And I hadn't been involved really up until that point in the diplomatic side of things, the sort of cooperation side. And I guess my parents brought me up well, so I knew how to use my knife and fork. I'm just kidding. But the point is, I learned that. That was something new to learn, is how to function in the diplomatic setting, to make the case for the ICC, to make the case for budget, that sort of thing. The court was overpromised. I think the expectations were set so high that they could never have been met by any human institution. I think this work is very, very difficult. The court's role as a fail-safe mechanism designed to intervene when states failed to discharge their responsibilities under their own statute did create challenges for us. But there were always ways to improve the efficiency of operations and to be more effective in how work was done. And even in the proceedings themselves, which tended, I found, to be very heavy. to try and streamline them, to try and make them work a little bit more agilely. These were things that we were undertaking, and I'm sure the current prosecutor is continuing to do that. I mean, I think in the end, you can only do what you've got the resources to do. That's that. For me, hearkening back to one of your earlier questions, I always found, except at the very beginning of my mandate, when the states parties decided to invest a good deal more resources in the court, apart from that one moment, if you will, I always found the budget cycle very dismaying. The fight we had to put out just to get the resources that we needed. And we were always under-resourced, and I suppose the court will always be under-resourced. And that is part of the challenge that the court faces in delivering justice. But the existence of the court itself is important. It's entered into the public imagination. People are called out for atrocities, often as a function of the ICC. You should be prosecuted by the ICC, even when there's no jurisdiction for the ICC to do it. And this is important because it's beginning to shape public attitudes, official attitudes, government attitudes, military attitudes. And this is important as well. So if you can do some really solid, exemplary cases successfully, that then feeds into an important narrative. So, I mean, it's a work in progress. I think the documentation you're speaking about it does provide an important source of evidence. The issue, of course, is its preservation, integrity, authentication. But I think the court, in its engagement with civil society particularly, has brought home to civil society the importance of recording and preserving evidence that they get firsthand, often while things are happening. And to ensure that that's available down the line for investigations or prosecutions when they can be undertaken. And there are a number of initiatives really from outside the court, but involving, as members of these projects, members of the court, or they were, to try and train civil society actors in how to capture, record, and preserve evidence so that it can be used in future criminal proceedings. But in this digital world in which we live, the real challenge for, I think, the ICC is to absorb all of this material, store it, preserve it, analyze it, and draw from it what is truly relevant to the investigations that they are conducting. But it's certainly an important source of evidence for any national or international investigative prosecutorial agency. What gives me hope is that it has always been a very long game. It is a long process. And there are going to be setbacks. There are going to be times when people will wonder, what's the point? But there is a point. You simply have to persist and to have the stamina to do that. I think, though, in terms of the evolution of international criminal justice, it's going to become more and more local, which I think is very positive. The ability of states to deal with these crimes is important. When you look at the Rome Statute itself, you have a grouping of states coming together. The promise to one another, we are going to repress these crimes. And my understanding is that the original framers of the statute thought that these states would then conduct investigations and prosecutions. If there was a failure, other states could then refer situations to the International Criminal Court. What happened instead was the sort of self-referral by a number of states, the waiver of jurisdiction in favor of the court, which then meant that the court's resources were suddenly absorbed, particularly by African situations by the states themselves, which had not been the anticipation, I understand, of the framers of the statute. And you only come far later into what I think they thought was going to happen with the referral of Venezuela by 6 states parties, and then after my time, the referral by over 40 states of the situation in Ukraine to the prosecutor. So I think the ICC will continue to have its role to play, sort of at the apex, if you will, of a multi-jurisdictional operation. But more and more, I think international criminal justice will be delivered where it should be, locally, at a national level. An example, I think, is Colombia. I was very much involved with the situation in Colombia, and it was always the hope that Colombia would deal with the dreadful situation that it had to deal with itself, and it seems to be doing so.